Hi, Mr. Tompkins. Thanks for coming in to meet with me today. As you know, we've been waiting for the Supreme Court to make a decision on our case against Erie Railroad. And this afternoon, I received the decision, but I'm afraid that they did not see the situation our way. So let me explain how the Supreme Court reached its decision and what that means to us. So when I first took your case, we discussed where we would file our lawsuit against Erie Railroad. And if you recall, I explained that typically a negligence case is covered by state law, but our situation was a little bit different. And that was because of the amount of the lawsuit, and that was coupled with you being a resident of Pennsylvania and Erie Railroad being a New York company. So that qualified us under what's called diversity jurisdiction to file our case in the federal court as opposed to filing it in the state court. So we ultimately decided to file the case in federal court because it's been a long-standing rule that judges would use federal common law instead of state law in diversity cases such as ours. And in a negligence case like what we have, federal common law would be more favorable to us than state law, which might help us win. So if we had decided to file the lawsuit in state court, the judge would have used Pennsylvania state law, which might mean that the court would rule that you were more at fault for the accident because you were walking without permission on private railroad property when you were injured. So things looked promising for us when we filed in federal court, and the federal district court decided in our favor, and they awarded you a judgment of $30,000 that Erie Railroad would have to pay. And then I thought we were really moving in the right direction when the Second Circuit Court of Appeals agreed with the first court's decision when Erie Railroad filed an appeal in the case. However, as you know, Erie Railroad took the case a step further and they asked the Supreme Court to review the case and to make a ruling on the decisions of the lower courts. And unfortunately, the Supreme Court justices did not agree with either of the lower courts, and they decided that Pennsylvania state law should have been used to decide if Erie Railroad was liable for your accident. And so ultimately what that means is that the $30,000 judgment that you received has basically been canceled, and we no longer have the authority to collect that money from Erie Railroad. So I know that it might seem unfair that the Supreme Court is using our case to change the long-standing process of applying federal common law to diversity claims that fall under state law. But the Supreme Court realized that parties to lawsuits have actually not been receiving equal protection under the law, and the circumstances of our case actually help them realize that. And so in the future, even if a court does not decide a party's case in their favor, we will at least know that they received equal protection under the law because of our case. So again, I'm really sorry, Mr. Tompkins, and although I know this news is not what you wanted to hear, I hope that you're able to understand why the Supreme Court made their decision and that you know that you will have an impact on many, many lives in the future.